Hello, everyone. My name is Mary Elston. I'm a visiting fellow at the program on Law and Society in the Muslim World at Harvard Law School. I would like to welcome you to this webinar hosted by the program on Law and Society in the Muslim World. Thank you to everyone who is joining us from the Harvard community, as well as participants from across the world. Before we begin, just a bit of housekeeping. Our audience will be muted throughout this webinar. The webinar will be recorded and made available afterwards on the social media platforms of the host program. We plan to have a 40-minute session followed by a brief Q&A. You may enter your questions into the Q&A box at the bottom of your screen, and we will try to get to as many of them as we can during the discussion. You may submit your written questions at any time throughout the webinar. It is now my pleasure and honor to introduce our speaker, Dr. Samy Ayoub, who is an assistant professor of law and Middle Eastern studies at the University of Texas at Austin. Dr. Ayoub specializes in Islamic law, modern Middle East law, and law and religion in contemporary Muslim societies. He focuses on the interaction between religion and law in contemporary legal and socio-political systems within a global comparative perspective. He has pursued training in both law and Islamic studies in Egypt, Scotland, and in the United States. Dr. Ayoub was selected as a fellow at the Netherlands Institute for Advanced Study from 2018 to 19. He also served as the president of the Islamic Law section of the American Association of Law Schools from 2018 to 19. And he is a member of the editorial board of Arab Law Quarterly. Next year, Dr. Ayoub is joining the program on Law and Society in the Muslim World at Harvard Law School as a visiting fellow. His dissertation and book, which we are discussing today, Law, Empire, and the Sultan, Ottoman Imperial Authority and Late Hanafi Jurisprudence, won the 2015 Malcolm H. Kerr Dissertation Award. Congratulations, Samy. It's wonderful to be here with you today. I'll now pass the proverbial microphone over to you to give an overview of your book, and then we'll have our discussion followed by the Q&A.
Wonderful. And I'm very grateful for the program on Law and Society in the Muslim World at Harvard Law School, specifically Salma Wahili, the Associate Director of the program, for inviting me to speak about my book. My comments, which will last about 10-15 minutes, will focus on the general arguments of the book and some of the background motivations and the directions of my research. So I will share my screen with me now, and so that you can follow up. I apologize. Trying to open the. There it is. Wonderful. So can you see the screen now? Sure. That's great. So as you can see here, so this is the image on the book cover, and it depicts Sultan Suleiman the Magnificent, ruled 1520 till 1566, while legislating in the Topkapı Palace, and it's a miniature of the so-called Suleymannameh. The Ottoman state emerged circa 1300s in the Western Asia Minor, not far from the modern city of Istanbul, and in a steady process of territorial accretion. The Ottoman state had expanded both west and east, defeating Byzantine, Serb, and Bulgarian kingdoms, as well as Turkish nomadic principalities in Anatolia and the Mamluk Sultanate based in Egypt. By the 17th century, it held vast lands in Asia, West Asia, North Africa, and Southeast Europe. The Ottoman Empire reached its height under Suleiman the Magnificent, when the empire expanded to cover the Balkans and Hungary and reached the gates of Vienna. After World War I, the Ottomans lost most of their territories in the Balkans and the entire Arab provinces. The Republic of Turkey was officially proclaimed on the 29th of October, 1923. So my focus in my book is about the Hanafi school, based on the name of the Ibn of the school, Abu Hanifa. And the Hanafi school was the administrative legal school adopted by the Ottomans. And Abu Hanifa was a jurist that was born in Kufa in the year 699, and that was during the reign of the powerful Umayyad Caliph Abdul Malik ibn Marwan. So Abu Hanifa lived for about 70 years, 52 of them were under the Umayyads, whom he witnessed as a child in their greatness and their power and strength, and as an adult in their decline and fall. And then 18 years under the Abbasid caliphs, two caliphs, specifically Safah and al-Mansur, for which he spent most of that time in prison, and he died 767. So the issue, so Abu Hanifa, as a figure, was very relevant to the Egyptian drama during Ramadan. So in the winter of 1997, the Egyptian state TV aired a series titled Al-Imam Al-A'zam, the Master Jurist. And these series are available on YouTube for free. And it was during the month of Ramadan, and really kind of growing up, so had some access and some information, not just on the academic legal training, but also as kind of symbol of kind of Islamic legal genius. Let me play just a very short clip of that beginnings of that series, if it works. So that actor passed away recently, unfortunately. I just want to show you the Umayyads and the Abbasids. Sorry. Okay, I'm going to stop here, and you can go on YouTube and check the entire series and the interesting songs that comes with it. So my book provides my book provides two key interventions with regard to the emergence of a late Hanafi tradition and the changing nature of Ottoman sultanic authority in the process of lawmaking. It is the contention of this book that analysis of Islamic law and society on the basis of a supposed epistemological conflict between law and imperial power is simplistic and inaccurate, at least in the Ottoman context. Instead, Ottoman jurists and late Hanafi jurisprudence in particular viewed Ottoman imperial enactments as authoritative and legitimate expressions of power. Late Hanafis affirmed that Ottoman subjects were morally obligated to obey the Sultan. However, they stressed that this authority was not absolute and that its validity was contingent on its meeting of certain objectives of the Sharia, such as fairness and justice in their understanding of these terms for sure. The incorporation of imperial edicts into authoritative Hanafi legal works by the Hanafi jurists was a sign of the indispensable authority of the Ottoman sultans in the lawmaking process. The book studies authoritative Hanafi legal works from the Ottoman world from the 16th till 19th centuries, casting new light on the understudied late Hanafi jurists, so-called al-mutaakhirun min al-ahnaf. Specifically, I interrogate the Hanafi legal tradition's portrayal of Ottoman political authorities and their local actors and agents. I incorporate empire as a mode of governance in the contestations about Islamic legalities during Ottoman rule. I analyze reformulations of Islamic law in the Ottoman imperial context and their lasting legacies in local and regional domains. Law occupies a central role in imperial governance. Ottoman sultans paid close attention to law because of its fundamental role in the preservation of social order. Exploring the relationship between law and empire invites us to consider the multiplicity of law and legal orderings. This approach, I claim in the book, expands the legal sphere for different analytical potentialities, and relieves the Islamic legal sphere from the burdens of the ideological packages and presumptions about law and society that accompany the context of nation states. Empires differ from nation states as political entities. The famous professor James Burbank and Frederick Cooper explained that, quote, the concept of empire presumes that different peoples within the polity will be governed differently, end of quote. And this exactly was the Ottoman model when they tried to govern and manage these very diverse population under the rule. Unlike state law, imperial law is negotiated, not imposed. Seeing law and empire as a paradigm allows us not only to demonstrate how legal traditions navigate and respond to the imperial will. Late Hanafi jurists, in fact, consistently include Ottoman sultanic edicts in their juristic discourses. I identify two ways in which the Ottoman state commands and prohibitions were incorporated in the Hanafi legal scholarship. The first way was the incorporation of the so-called Ma'rudat Abu Saud Effendi, literally the representations or submissions, and they were collected, and they were a collection of legal opinions, fatawa, issued by the famous Ottoman Sultan, the famous Ottoman jurist, who was appointed Shaykh al-Islam as well, under Sultan Suleiman, Abu Saud al-Imadi. He died 1574. So these collection of fatwa were presented to Sultan Suleiman and were sanctioned and were adopted by the state for issues of governance and policy making across imperial centers. The second way was the direct references to sultanic edicts that Hanafi Jews included in the legal discourse. So my analysis here shows that late Hanafi jurists assigned probative value and authority to Ottoman state edicts. And this authority is reflected in the Sultan's ability to settle juristic disputes, to order specific opinions to be adopted in legal opinions, and to establish his orders as authoritative and final reference points. So I claim in the book that the incorporation of sultanic edicts and orders into Hanafi legal commentaries and treatises and fatawa collection was made possible by a shift in Hanafi legal commitments that embraced the sultanic authority as an indispensable element of lawmaking process. I use the term sultanic authority to refer to the political power within the Ottoman Empire. The Sultan's legal authority is a reflection of his power and his ability to enforce order. Late Hanafi jurists use the terms الدولة العلية, السلطنة العلية, الدولة التركية, الدولة العثمانية to acknowledge the authority of the Sultan in the legal scheme. So just briefly, I will mention who are those late Hanafis that I spend the entire book talking about. Especially the label متأخرون is a very contested term. It's not specific, but yet is very relevant and very used extensively in that literature, especially post-15th century. So I propose in the book that late Hanafism as a category emerged around the 11th century. However, it manifested in a fully fledged tradition in the early modern Ottoman Empire. In Hanafi legal writings, there are no specific criteria to define early versus late. The terms are relative. We are told that early Hanafis are jurists who saw or met Abu Hanifa, and that was very early. So Abu Hanifa died in 767, and his disciples, Abu Yusuf and Muhammad al-Shaybani. Okay, so to continue, so in this book, I propose to approach late Hanafi jurists in terms of their self-identification and the legal patterns of, in their legal opinions and norms in their scholarship. I'll try to share again with you my, okay, I think I can share now, but hopefully soon we'll give them the privilege to share my screen. If you can do that, Mary, it'd be great. So for instance, the appellation late Hanafis appear in the title of a famous biographical dictionary by the famous شمس الدين محمد بن طولون الصالحي الدمشقي. It's called الغرف العالية في تراجم متأخر الحنفية, specifically a legal treatise or biographical dictionary that has been written only on those late Hanafis that the author identifies. The work was written in the first half of the 16th century and remains extant in manuscript form. And Ibn Toulon starts his work by providing biographical information on the founders of the school, and then the first Hanafi that he identifies as late is all these jurists that lived in the post 15th century. So also the label late Hanafis appears in a specific type of genre, like the fatawa literature, for example. And we can find that in this here, in the screen here. This is still in manuscript form. It's a work that has been authored by Jamaluddin al-Hanuti. He died 1601. And the title is called إجابة السائلين بفتوى المتأخرين. So answering the questioners on the basis of the fatwa of the late Hanafis. So here specifically, the author, when he tried to build up his own narrative about who are these late Hanafis, he specifically mentions most of the Hanafis that he engages with are those who are post 13th century. So here, late Hanafism is not just a label that refers to a particular type of individual, but rather it's a tradition made of certain networks, texts, and kind of layered type of authority in which these Jews are engaging with. So furthermore, the Hanafi jurists from the 16th to 19th century employ a number of specific phrases to show the fully developed nature and maturity of their own identity. For example, the phrases that you can find, something like أجمع المتأخرون, the late Hanafis agreed upon. اختلف المتأخرون, the late Hanafis differed among themselves on. طائفة من المتأخرين, a group of late Hanafis. عامة المتأخرين, some or one of the Hanafis. كثير من المتأخرين, many of our late Hanafis. مشايخنا من المتأخرين. شواذ بعض المتأخرين. It goes on and on. This is a very serious and a very clear type of literature, a body of knowledge, and as well as texts and authorities that form that late tradition and its synthesis in the school. So in the book, so here I think you can see here in the screen in front of you, this is how somebody, I believe in Radd al-Muhtar ibn Abidin, you'll find this type of almost like a binary with regard to what the Mutaakhirin state on certain issues and Mutaqaddimin said something else, for example. To give you an example here, I think the second example here, ويجوزون ذلك على ما يأتي والمتقدمون يجوزون ذلك على ما يأتي الإيجارات, and then we can find here عدم حل أخذ الأجرة على الأذان والإمامة على رأي المتقدمين. So basically is making an example that when it comes to lease, the issue of contract to lease, it's certain time it seems that the late Hanafis have a synthesis, have a position, and that position adopted for their own legal opinions, and that acknowledged and understood among themselves that is very different based on what early Hanafis used to adopt, for example. So in the book, I use the label late Hanafis of the early modern period, both to be faithful to the way in which Hanafis refer to themselves and conceive of their own legal positions in the school, as well as to kind of capture the school and the chronology of their of the development in that time period. So, so in principle, the division between Hanafi jurists into early and late groups is not simply a matter of time. Although it is true that late Hanafis legal works post-date those of the early Hanafis, I see late Hanafism as an amalgamation of methodologies, texts, authorities that managed to reinterpret Hanafism in the early modern period. So I will just end by saying a few words and then give the floor to Mary here, that I see the Islamic legal system by its very nature is authority bound. That is, jurists rely on authorities higher than themselves to expound the law. The continuity of the late Hanafi legal tradition was guaranteed through the composition of commentaries on authoritative legal texts and through adherence to the madhab hierarchy. The continuous legal endeavor of late Hanafis to gain its authoritativeness and its value from the perpetual explanation and expansion and contentions and examination of the Matun and the Shuruh and the commentaries that came before them. I claim that the ramifications of my study go beyond the simple identification of a process of legal change or a continuation of the madhab in certain direction. I claim that the continuation, that the late articulation of the madhab in the Hanafi school are particularly important because they have a direct connection to the Ottoman state, and they have certain relevance and importance that the debates on codification in the modern period, as well as what it means to really govern a very diverse empire that the Ottomans did. I'm going to stop here. I'm going to give the floor to Mary, and thanks so much for your patience, and apologize for the connection problems that I had earlier. Thank you.
Thank you, Samy. That was a very illuminating presentation. And I'll just say I really enjoyed reading your book. I learned so much. And one thing that really excited me about it is that my main exposure to the idea of the mutaakhirun had really come in the writings of late 19th century reformist thinkers like Muhammad Abdu, who are actually generally very dismissive and critical of the mutaakhirun. So it was wonderful to look at your very careful and analysis and elegant, I thought, analysis of what constituted the late Hanafi madhab in the centuries that you were looking at. So yeah, thank you so much. I wanted to begin our discussion with a methodological question. You in the book focus in particular on positive legal works of the late Hanafi scholars, the furu'. And you differentiate your approach from scholars who have approached the relationship of law and society in the Ottoman Empire by looking at court records and registers. And I wanted you to sort of elaborate on this choice, because I think my impression from your book is that you see limits to what court records and registers can really illuminate in terms of the development of the legal discourse. So if you could first just comment on that a little bit.
Thanks so much, Mary. So with regard to my choice, why I focus on positive legal works, for two reasons. Number one, court archives give us a very important and rich picture of litigation and how Muslim judges, Hanafi or Shafi'i or Maliki or Hanbali judges, worked across imperial provinces. However, that does not give us insights about the central domain of Islamic legal discourse, that is the fiqh tradition. The fiqh tradition, part of the problem, it is massive, it is tedious, it requires a lot of time to go through all of these texts, and requires certain type of familiarity with certain type of jargon that is kind of germane to the ways in which jurists employ for their own sake. So for me, court archives are insufficient to provide these type of insights and these debates among jurists, and they are helpful to tell us about, as a matter of governance, as a matter of administrative policies, how the judges were appointed, what type of decision is to pass, and things like that. This is very important. And if you are appointed as a Hanafi judge by the rules of the Ottoman Sultan, in your appointment letter, you get saying that you have to abide by the preponderant opinion of your school. So even then, if you want to explain or look carefully into this court archives, will require some knowledge of how the madhab positions came to be, and why this scholar or that jurist or that judge, if was appointed, reached that conclusion in certain cases or not. So here, that tension, I think, is really important to highlight, that the court archives would never been held as authoritative by jurists themselves. No jurist will go back and refer to a court decision. So really, in short, it's about how jurists themselves view the value and the authoritative standing of the court archives, but also is about the function of the judge is very different from the function of the jurist who's practicing and engaging in their own legal school. and sphere.
Thank you. I was hoping you could describe a little bit a very important figure in your book, Ibn Nujaym, who I'm not sure if you talked about him in your introduction just now, but he was a 16th century Egyptian Hanafi jurist who I believe you describe as the quote unquote father of late Hanafism. So I wanted you just to provide a little flesh to your argument to describe sort of his importance in your argument. And I personally am very interested in his work Al-Ashbah wa Nadha'ir, which plays an important role, I think, in actually almost of your chapters. So if you could just provide a little bit of detail as to the significance of him and that text, that would be wonderful.
Thanks so much. In my acknowledgement of the book, I do mention Nujaym to be somebody who really inspired me to look more carefully in the Hanafi tradition. I kind of started first in Egypt, since I was more familiar with these type of texts there. So Ibn Nujaym was born and raised in Egypt. We know very little about his early life, but he was close to Abdul Wahab al-Sha'rani. He went to Hajj with him. And he authored one of the most important, I would claim, texts that really came to influence any other texts that came after him. And that on both of his fatawa and his rasail, as well as his shuruh, his commentaries. So Ibn Nujaym has a brother, his name is Omar as well, that he wrote Al-Nahr al-Fa'iq, and Ibn Nujaym, our figure, Zainuddin, he wrote Al-Bahr al-Ra'iq, and his brother wrote Al-Nahr al-Fa'iq, and both on the same texts, and Nasafi. And you can see that both brothers did disagree with each other in certain areas here and there. So his really importance comes from two things. Number one, his erudition. He's a very tentative, very careful jurist. Professor Johansson, Abiba Johansson, did write a book about the issue of land tax in Egypt and the history of that. And Ibn Nujaym plays a key role in the Ottoman administrative practices, especially the changing of the nature of lands from being privately owned or to be now state land and things of that nature. Really, it changes and gives the Ottomans a lot of tax revenues to tap into. So, so for me, the importance of Ibn Nujaym, kind of reflecting back on the book, comes from that how later generations of Hanafis view him, and how his works, even till today, play a central role in how people speak about fiqh in general. Some of this genre, as you mentioned, Al-Ashbah wa Nadha'ir, which is kind of combination of kind of the fundamental basic principles that he sees to be kind of generate and maintain the fiqh tradition. That if you use, especially this text is to be actually used for, I think, beginners who've been trained to be jurists. They kind of given some of these basic principles upon which that they use in order to kind of understand what really the system is. Hanafi school in general has kind of universal, so Hanafis view the law to be a rational system that requires a type of legal capacity and intellectual acumen. And they assume that that the tradition of the Ashbah wa Nadha'ir will give you much more and enhance your capacity to really understand what Hanafis understand the system to be. What is the foundation of this order, and things of that nature. So can I hope that I give you a bit of about Ibn Nujaym and his importance?
Yeah, thank you so much. So in your book, in chapter 2, I believe, you, in describing the late Hanafis, you distinguish between the Mamluk and the Ottomans, and particularly in terms of their relationship to sultanic authority and its role in legal reasoning. Could you flesh out some of those differences? And in doing so, could you also comment on the way you see your scholarship intervening in academic conversations about the relationship between Sharia and Qanun in the Ottoman Empire?
Thanks so much. So that's a great question. With regard to late Hanafis of the Mamluk period, we find kind of early iteration of that the Mamluks really started to have interest in managing how legal institutions, especially judicial institutions, are operating. So they have this Dar al-Adl, and they started appointing judges and started to have certain positions about what certain legal opinions should be taken as policy considerations and things of that nature. And we have plenty of examples like this, but most of these examples are not included in the furu of works. So most of these examples that you can see, most of them, I would claim, exist in history and historical anecdotes. I think Zahir Papers, I think, has some interest in Awqaf, has debates with the scholars, the Shafi'is and the Hanafis and the Malikis, sit down with him, and was some pushback against some of the claims of some Mamluks wanted to actually control some of the Awqaf. So early on, that type of relationship has always been tested, but at the same time, you'll not find in Mamluk Hanafis, in Mamluk late Hanafis, you will not find direct references to Mamluk Sultanic positions in their works. None. There's no legislation from or the understanding that these Sultanic orders has any sway on on their own normative positions as they exist in the Furu al-Fiqh. So that's number one. Number two, what comes to Mamluk Hanafis, even other jurists, it seems that when you look at the kind of compared to Ottoman Hanafis, Ottomans provide, it seems, a new conception of governance, new kind of way that they choose to manage this massive territorial empire. So there's new conception of governance. I think my colleague Guy Brock, his book about the second formation of Islamic law, it really touches specifically on how the Ottomans intervened in the legal system and how they have now a legal hierarchy that they can appoint jurists and judges to really work for the imperial positions across the empire. But for me, I don't see these things, especially in the Ottoman context, to be interventions. For me, I see that the Hanafis themselves engaged and embraced that position to be normative. The Ottomans were not really pushing the Hanafis specifically to how to let go of their authorities in the school, but really was understanding that if this is going to be helpful for them as administrative legal school, some compromise had to be reached, and that went in that direction. Guy Brock makes the observation accurately that these Hanafi jurists that existed in Anatolia, for example, was much more susceptible, much more open to adopt and sometimes defend some of the Ottoman policies with regard to a whost of issues. That conversation is totally absent from the late Hanafis in the Mamluk context. The Hanafis in the Ottoman context saw the Sultan and his position as an office, not as just a person. It's not just we are paying the Sultan. For example, some Hanafis in the later period insisted that every Ottoman Sultan who passes away or being pushed out of power and things like that must reauthorize the Sultanic edicts that the previous Sultan has issued. So this really gives you an indication that there's a growing interest and understanding of the increasing authority of the Ottoman sultans in these legal spheres, unlike anything else I've seen before.
Thank you. Yeah, just touching on something you just said, one thing that really struck me in your book is that even though you're describing sort of an increased role for sultanic authority in late Hanafi jurisprudence, you really are not portraying these jurists as apologists of the state. And I wonder if you could elaborate on why you don't see them that way, and where you see sort of where they're limiting sultanic authority or critiquing the state at the same time that they are relying on that as an authority.
Wonderful. So, so the question when it comes to the relationship between the Ottoman Sultan and Muslim jurists is complicated, but so I reject the idea that somehow Islamic law existed outside of history, outside of politics. Law is part of the political. Law cannot exist outside of political institution. It requires enforcement, it requires support, it requires social and political backing to be able to really to make it relevant in the time that the Hanafis really try to articulate norms for the empire. So, so I don't see the somehow they are operating outside of that space. Second, the idea of independence and the idea that Islamic law is based on the expertise of jurists does not go away in the model. But the idea that Hanafis must be and somehow must be, kind of stay outside of government so that it can be dependent. Well, I'm not sure if this has ever been the case. Second, it seems that Hanafis were willing and they did and were interested in even serving as judges. In the early period, for example, the story that Abu Hanifa refused to serve as a judge in the Abbasid Caliphate, and that's why he put in prison for almost 2 decades. In the later Hanafis, this is, look, to be a corrupt judge is a problem. To be a corrupt judge is sinful. To be a corrupt judge is something that must be condemned. However, if you are a good judge, you're going to rule according to what the Hanafi school is saying, this something can be good. This is something that they actually praise. This is how it makes Islamic law relevant to population. This is how allow Muslim empires and Muslim government to actually assert its authority in all these population and govern them. So the idea there, at least for Hanafis who were very close to Ottoman authorities, and not just those who were close to them, even in Egypt, like Ashrambilani, for example, that I mentioned in the text, he was never appointed into an official political position. Although he was very prominent, I think he was appointed to be the head of the Hanafis. I don't think that was an official position. But again, he does recognize the Ottoman authority. He has no problem at all of asserting the moral position of the Ottomans, yet at the same time, they criticize certain positions, especially policy issues that the Ottomans adopted by preventing farmers from leaving the lands to just stay all year there in order to kind of basically farm the land and levy taxes. They can exercise certain type of unjust policies with regard to punishments. So things like these, the Hanafis did not shy away from criticizing them. At the same time, they had and have no problem to assert and maintain the authority of the Ottomans to be legitimate Muslim rulers.
Great. So Samy, at the heart of your book is an examination, I would say, of both continuity and change within the Hanafi madhab. And so I'm curious if you can articulate how the jurists sort of legitimized the changes they were making. If you could give a few specific examples. And then I'm also curious if you could comment a little bit on the degree to which what they were doing was articulated in relation to the concepts of ijtihad and taqlid.
Wonderful. So that's a very good question, because even after the Ottomans, the question of ijtihad and taqlid became a key part of the Muhammad Abdu and those who came with him. So in that later time of the history of the Hanafi school, we have a very robust legal tradition. And I would say even not just, I would say it's a mature legal tradition. And legal traditions by nature, especially sophisticated, multi-layered one like Islamic law, because it's a well-developed order, it's really hard to change positions in it. And as I mentioned before, if it's the system is based on is authority bound, that your authority is not just based on your legal acumen or just your legal expertise. It's also based about how you articulate that position or new positions in the school and the the structures of authority in which that you're operating. So the question becomes that it's basically, I see that as any kind of ijtihad fil madhab. It's independent legal reasoning within the framework of the legal school. That's hard to do, but one of the examples that the Hanafi is able to do that is by appealing to the founder of the school. It's a famous statement mentioned by many Hanafis since Ibn Rujaym till Ibn Abidin and the famous 19th century Damascene jurist. He says, لو كان أبو حنيفة هنا لقال مثل ما قلت. If Abu Hanifa were here, he would just say the same I'm saying. Or if لو رأى المتقدمون ما عليه المتأخرون لقالوا مثل ما قلنا. If the early Hanafis have seen what the late Hanafis are experiencing, they would have adopted our position. So the issue there is not just a rejection of early Hanafis, but rather is really understanding that the early position is contingent, and the late Hanafis had to provide new understanding and the new positions for issues that no longer really early Hanafis position can stand. issues about التداوي بالنجاسات. So there's not in the book, can put it aside. But for example, Hanafis, especially in the later period, were much more willing to adopt, especially with the medical inventions in the 19th century, was much more open to some sort of medical experiments that might involve ritually impure materials. Early Hanafis, especially the majority of them, would have problems with that. Later Hanafis changed the position. The example I gave from Ibn Rujaym about al-istijar al-ta'at, how to pay a teacher, a tutor who teaches my son the Quran, or in the masjid, for example, which used to be, well, teaching the Quran is an act of worship. You cannot really pay money for it. Well, the Hanafi says, look, these people, this livelihood is teaching the Quran. This livelihood is dependent on the ability to have students and teach them. And there's no problem for them to ask for fees for this time. And the money is not just for teaching the Quran, the money is for the time. So that type of reasoning does not happen in the sense, oh, the early Hanafis are bad or something like that, or we have to do ijtihad outside of the Hanafis, but rather early Hanafis has interesting position, but that position is no longer possible because it's contingent in its own specific circumstances. As I can plenty of examples in this regard. They even disagreed with the founder of the school on so many issues. For example, the definition of al-ghasb, as I mentioned in the last chapter, for example, which kind of for Hanafis usurpation of property only meant when somebody take a property for sees a property for somebody, but not just that, and he enacts some actions in it, like selling it, putting it in his own safe, or putting it in his house, then it's a seizure, kind of, or wrongful appropriation. Later, Hanafi says no, the mere seizure of the position is sufficient. So that's how Lit Hanafis really changed the position in the school. There was definitely a lot of ijtihad happening within it. It's difficult, it's subtle, but it requires understanding how they to do that, and to what extent that can go.
Thank you. Before we move to the questions from the audience, I just want to have us discuss a little bit the modern period, because this was a really exciting and fascinating part of your book. I guess a few different questions. It'd be great if you could provide, the audience with some understanding of how you approached the Ottoman Majella in 1876. My understanding from what you wrote is that you're really approaching the Majella through a different frame, rather than looking at it through the lens of epistemic rupture brought by colonialism and westernization. As you did with the earlier centuries of late Hanafi jurisprudence, you're underlining continuity and change within the madhab and how you approach the Majella. So if you could provide a few details of how you see that. But then my question to you is, you still see this as part of the modern period. There is something unique in the transformation of law in this period that you don't see as epistemic rupture, but you do describe it in other ways. So if you could describe that. And then finally, when does late Hanafism end? Like, when is there actually a rupture? Do the jurists in the 21st century count as late Hanafis, or do you see that break happening somewhere else in the 20th century?
Thank you. This is a wonderful question. So for the Majella, this was a difficult chapter because the existing literature really has an almost a unified way of looking at it. And I don't disagree entirely with that thesis. In that chapter, I claim that the first Ottoman civil law, or the Majella, was an Islamically informed response to the emerging hegemony of European laws in the heart of the empire. And the Majella was enacted in 1876. And that by time, really, we having Egypt almost really run by foreign powers, officially became a British under British colonial rule in 1882, and we're starting seeing a French now encroaching in Algeria and Tunisia. So the empire really starting to struggle with some of these matters. But the Majella was an effort on the Ottomans to kind of start training judges without having them to be immersed in the madhab tradition. So these judges who might have been trained maybe in some other legal traditions would be now trained in the Majella to be applied specifically in the Nizamiya courts. I think it's a famous book by Avi Rubin, specifically on these courts and the operations inside it. So But the issue there too was that these assumptions on the habit of the Majalla were usually just general observations about it without looking carefully into the content of the type of articles that was included in it, which is 1,800 and maybe 32. And in these articles, especially in the chapters and the report that joined the Majalla to kind of was raised by Ottoman Sultan and to sign it, you can find what is the rationale and the motivations that were given why this project is very important to the empire. Key among it, at least for me, that it signals, again, it is explicitly mentions in the report that it is meant to counter European hegemony within Ottoman domain. So at least this is the unstated agenda in the article, and Islamic law is very important to them, and codification of aspects, especially that's commercial aspect, is very important since the Ottomans have lots of kind of international trade, so complaints about kind of difficulty to engage in business with the Ottomans, and why Islamic courts sometimes restrictive and things of that nature. Key among them, which is in the Majalla, as I mentioned in the examples, that testimony is no longer just limited to Muslims or those who act on behalf of the Muslims in the court. Now the witnesses became somebody really just in good standing and known to be as such. And the issue of religion disappears entirely from the conditions that have been required for somebody to appear in front of a Muslim court. And kind of a few other transformations. So the Majalla is a complex project. It has, they do recognize that it is informed and it is operating in a particular setting. The French code, very, very popular among some Ottoman officials. There's even such a type of claims and even demands or proposals that we just adopt French law, code as is. So the push against that, especially by Ahmed Reza Pasha, one of the key figures as part of that Majalla. And the Majalla itself, as I mentioned in the chapter, is an Ottoman state project. It is maintained and sustained by Ottoman officials, and it did include the son of Ibn Abidin, Ala-Eddin Ibn Nujaym. That was for 10 years, and then he left, and people left the Majalla committee and came back, and some others kind of quitted. So even Shaykh al-Islam at some point just left and came back. So some debates and issues about what is exactly going on.
Great. We're running out of time, so we're going to return to the audience questions. The webinar is now going to end at 1:05 due to our technical difficulties. So Samy, I'll read the questions that we have from our audience. The first one, can you provide an example of how law was negotiated between subjects and Ottoman authority, and how different laws were decreed in different regions of the empire?
Okay, to how the law was negotiated. So what comes to mind immediately is maybe we'll focus only on the Egyptian context here. There was some problems about waqf al-nuqud, which is a particular type of transaction in which people can set up endowments based on cash, which was contentious in some parts of the empire. That was known specifically for Central Asian Muslims, and especially in the 17th century, there was a migration from Istanbul to Jerusalem. So that type of transaction was known specifically in Anatolia and later in Jerusalem. In Egypt, that was rejected, at least partly. So what happened is that the Ottomans and the Egyptians, like Ibn Nujaym and others, did reject cash endowments in Egypt. And they said, well, if you'd like to have cash endowments, you can go to Jerusalem and go to Anatolia. So that type of reconfiguring certain positions that most Hanafis will not even today think about was possible in that context. And cash al-nuqud as a matter of registering. So go to a judge in order to register that endowment. That was not possible in Egypt, as far as I understand, at least until the kind of late 18th century. So this is an example. When it comes to non-Muslim minorities, for example, the Ottomans did and had kind of some sort of representatives on behalf of the Jews or Christians. to manage about places of worship, to manage how they will govern Ottomans created certain official positions on behalf of each community. And in Egypt, the famous Khat Hamayoun was probably negotiated about what type of places of worship is possible for Christians to have. And I think the famous incident in Egypt in the 16th century when the Ottoman issued a farman to allow an old church to open, and that was not possible in Egypt, even against the will of the Sultan, because locally there was some sort of opposition to it. So, so these things, again, highly contingent, at least historically, and as a legal position, it seems some margins by which some of these things can be negotiated.
Great. So the next question, can only Hanafism develop the specific expanded relationship of the law? Did only Hanafism have the intellectual possibilities to develop in this fashion? Or had the Ottoman sultans adopted Shafi'i or Maliki as their school? Could we also speak about late Shafi'ism and late Malikism?
So when it comes to the Shafi'i school and the Hanafis, at least in the eyes of the Ottomans, these schools were legitimate and they were very important to govern the provinces. And the Ottomans only send the head, the kind of chief justice or the chief judge to Egypt every few years to kind of to renew the position. But that chief Hanafi judge, most of the judges underneath him, the Nawab, used to be from other legal schools, Shafi'i and Maliki in Egypt, kind of things like that. The Ottomans had some problems with some Shafi'i positions, especially when it comes to issues of al-mafqud, the lost person. So many men used to fight in the Ottoman army and they never came back to their wives. And these wives for the Hanafi school was, I think, really difficult to get divorced or even inheritance. So they almost in limbo. So what happened is that in Anatolia, we have all these women suddenly became Shafi'is. They just went, okay, let's just move to Shafi'i school. I want to get done with my life and move on. So one of the Ottoman Sultan issued something against at-tashaffu' and actually banned the Shafi'i school in Anatolia for some time. So so I would say, again, here we can see here the Ottomans banned Shafi'i school only on the level of, again, so only on the level of the judiciary. It does not mean people cannot be Shafi'is anymore or just practice Shafi'ism as a tradition. But certain positions the Ottomans saw to be problematic as a matter to govern the empire in a way that we thought to be meaningful. So in my last article that I recently published on casting off Egyptian Hanafism, I was able to find an Ottoman document that was, I would say, published in the late 17th century, maybe 18th century, I don't remember the date now, but in which the Ottoman Sultan issued a letter to the Mashiach preventing them from hiring non-Hanafi judges. Non-Hanafi judges. It's unclear if that farman went into effect or not, or the Hanafis had now the upper hand ultimately. But what I know that in Egypt, in order to be able to appoint as a judge, really had to be Hanafi. And if you are even a Shafi'i, you have to be in the Hanafi school and then become a judge. You can be a Shafi'i jurist, you're welcome, but not as a position as a judge in the empire.
Thank you. Another question, this person writes, you seem to use two modern, ideologically and politically loaded concepts, empire and the state, freely, along with the Sultan, to talk about the source of legal authority, and do not engage with them in the way, for example, Wa'il Halaq does, which you critique. Can you comment on that?
Thank you. So the question of my engagement with Wa'il Halaq position is that when we speak about the nation state model, its conceptions, at least theorization and its authority, its sovereignty over its citizens, and the package that comes with it, really I think limits our ability to read carefully how Islamic law manifested. Islamic law really needed at least in Sunni Islam, needed the Sunni, the Ottoman Caliphate in some respects for Islamic law to be able to be functional. And when I say that, it seems to me that So here empire is not used in a kind of in a pejorative manner. It's just the way in which in kind of history of the world used to happen. So we do have imperial governance. The Ottomans were part of it, and in that framework, all I claim is the following: if you think that Islamic law somehow functioned the same way in its imperial context compared to what we see today in the modern nation state, I think we're going to have a problem to see that. Second, halak see any type of any sort of quote unquote intervention by any political authority in Islamic law. He sees this as a sign that is bad for Islamic law, that is necessarily limit and the authority of the jurists, and that necessarily bad for fiqh, and is not certainly a sign for lack of independence. So I think that that position cannot be really tenable in light of the history of Islamic law, in which we can see some conversation, some negotiation, some tensions. And I don't want to really overstate my position with saying that the Ottomans really all the time the Hanafis adopted. Rather, no, I have a very really conservative position saying that the Hanafis understood the authority of the Ottoman sultans. They acknowledged them, they incorporated them in that limited fashion, and this is some examples. And this is, I think, later to kind of lay some important foundation to go beyond that narrative that Islamic law kind of suddenly goes out of the window once the Ottomans or the Mamluks start kind of emerging in the empire. So this doesn't seem to be kind of accurate historically, at least.
Thank you. I have to apologize that we have run out of time and we cannot go through all of the wonderful questions from the audience. But Samy, thank you so much for this wonderful discussion. Thank you to our audience again for your engagement and wonderful questions. Thank you to the Program on Law and Society in the Muslim World, the host of this webinar, and also a special thank you to those behind the scenes who brought us this webinar. We look forward to welcoming you to future discussions. May you all stay safe and healthy wherever you are. So thank you.
Thank you so much, Mary, and thanks so much, Salma.